be talking about retirement plan trusts. Another title for this speech, which actually could be a title for any speech that I give, is how to protect your family without having to give up control. And one of the things we're going to talk about is the sooner you plan, the more control that you can maintain. So what you're going to discover today is ways to promote family harmony. So how to make sure that your family gets along after you're gone. How to leave a legacy. So how to leave the money behind in a way that it doesn't ruin the people that you're leaving it to. As I've told you in my other speeches, most inheritances are treated exactly like lottery winnings, which then means they're blown within a year. And so I'm going to talk to you about some ways that we can protect against that. How to save taxes. So one of the important things with your retirement plans is you put that money away tax-free. It grows tax-free over your lifetime. And then when the money's pulled out, somebody has to pay income tax on it. And we're going to talk about some strategies to make sure that they don't have to pay too much in the tax. So a little bit about our firm before I get started. We've helped over 6,000 families protect the assets that they leave to their loved ones from divorce, creditors, and lawsuits. We've also helped over 900 families implement the plans that we've designed, and over 2,400 families implement the plans that other attorneys have designed. And why that's significant to you is for most people, estate planning is kind of depressing. So you're going to want to put together a plan, put it on the shelf, and forget about it. But what's important to you is that it actually works when you need it. And the fact that we've walked alongside these families and had it work as smoothly as possible gives you the peace of mind that it'll work smoothly for your family. Our firm is unique in that we do estate planning and elder law. So estate planning is what we're talking about today. It's the who gets your stuff when you die. Also talks about retirement plan trusts. Elder law is protecting assets for Medicaid, and we talk about that in other speeches. When you work with us, you get the experience of not only the attorneys in our firm, but also 3,000 attorneys nationwide. We belong to a lot of organizations, and we can learn from those other attorneys to make sure that things go as smoothly as possible for our clients. We have 3 locations, and we can meet with you at any one of those locations. We have an office in Aubrey, an office in Bartonville, and an office in Denton. And then we have several books. If you're interested in them, you can contact our office to get a copy. First one is my most popular book. It's Who Gets Your Stuff When You Die. The middle 2 books are Will Your Spouse Know What to Do If Something Happens to You, and Will Your Family Know What to Do If Something Happens to You. Those have really good checklists of things that your family would need to know if something happens. Those checklists are also on our website, so if you're interested in getting them, you can also download them. And the final book is Finding Strength in the Face of Alzheimer's. I wrote this book because I've had a lot of clients either have Alzheimer's or care for somebody with Alzheimer's. Most important advice in the book is to be sure and take care of yourself if you're taking care of somebody else. So today I'm going to talk to you about your biggest problem asset, your retirement accounts. Now when I say that, you're probably like, I don't have any problem with my retirement plans. Why do you think that they're a problem? Well, one of the biggest problems with retirement plans is the taxation that happens when the money comes out. Also, your retirement plans are your most likely asset that you're going to leave behind. So most of my clients who are required to take out minimum distributions, they actually complain about having to take that money out because they don't want to pay the income tax on the money. So because of that, that is really going to be the last money that you spend because you're not going to want to pay the tax any sooner than you have to. So when we're talking about retirement accounts, we're talking about traditional retirement accounts. Those are the ones where you put the money in tax-free. It grows tax-free over your lifetime, and then you pay income tax when you pull it out. I'm also talking about Roth accounts. So Roth accounts are ones that you pay the tax up front. It grows tax-free over your lifetime, and then when it's pulled out, there's no income tax on it being pulled out. We're also talking about 401ks, 457s, 403bs, KEOs, and any other retirement plan that lasts beyond you. What we're not talking about with retirement plan trusts is pensions, because pensions last for your lifetime. Maybe they pay for a period of time for your spouse, but they don't go to a non-spouse beneficiary. Retirement plan trusts are designed to protect assets when they go to a non-spouse beneficiary. So let me talk to you about the potential problem with taxation. It's actually a potential double taxation. So in the event you have enough money that you're subject to estate taxes, the federal government's going to take about 43% of the money over whatever the exemption is. Then second tax on it is going to be the income tax on pulling the money out. And this actually can end up eating up a big chunk of the retirement account. Now, many years ago, I had a client when the exemption was only $1 million, and she inherited a $3 million IRA from her dad. Because his retirement plan was in a 401k, the company actually required that the money come out in 1 year. So she inherited this $3 million. Because the exemption was $1 million, what ended up getting taxed was $2 million of the $3. The tax was approximately 50%, meaning the government took $1 million in estate taxes off the $3 million. Then because she pulled the whole $3 million out in 1 year, she had income tax on $3 million, which about a third of it went to that, which is another $1 million. And then in that particular year, there was an excise tax if you pulled too much out of a retirement account in 1 year. And that was a 15% excise tax. Now, they offset each other a little bit, so it's not quite the numbers that I just said, but pretty much out of the $3 million, she ended up with a little bit less than $1 million. So one of the things we've got to watch on retirement accounts is to make sure that the taxes don't eat up what you're leaving behind. The other thing that's kind of a sneaky thing, and it's not actually a tax, it's a surcharge, but it works the same as a tax. If you earn too much at the point where you start taking Medicare, they actually charge you more for your Medicare supplement than they do somebody who doesn't earn over a certain amount. So if you were to take a large amount out of a retirement account in 1 year, during the period of time that you're receiving Medicare, you're actually going to pay more in your Medicare premiums than somebody else would. And over your lifetime, you'll end up spending $500,000 more on your Medicare premiums than somebody else would. So there's new RMD rules under the Secure Act. So prior to the Secure Act, when you left it to a non-spouse beneficiary, they could take it out over their life expectancy. And that was wonderful because we could have the money grow tax-free for a number of years. And it was actually pretty much 80 minus their age. So if somebody was 20 years old, they could take it out over a 60-year period. When the Secure Act passed, they changed it to where most beneficiaries who are not spouses have to take it out over a 10-year period. There are a few exceptions, one of which is if it's your minor child. So if you have a child who's under the age of 21, and that's the person is a beneficiary of your retirement account, they get to take it out slowly till they turn 21, and then it's a 10-year payout. Another exception is if one of your beneficiaries is disabled. They're allowed to take it out over their lifetime. But one of the quirky things with the Secure Act is if you have a disabled beneficiary, the only way that they get to take it out slowly is if we have a separate retirement plan trust that has the special needs trust provisions in it for that beneficiary, and they are the sole beneficiary of the trust. So if you have a beneficiary of your retirement account who is disabled, you need to make sure you're working with an attorney that knows what they're doing, because if they do it wrong, they make the money have to come out quicker and it's taxed over a shorter period of time. So one of the ways you could do it, if you decide you don't want a retirement plan trust, is you can name individuals directly as beneficiaries. But there's several things that can go wrong with that. One is the beneficiary may decide to cash out earlier than required and blow the stretch out. So they may not realize that they have 10 years to take the money out. They may take the money out too quickly. I've actually had people who have inherited retirement accounts not realize that they could take the money out slowly. They take it out of the retirement account, they invest it wisely, and then in January they're surprised because they get a 1099 showing they owe tax on the entire amount of money. And there is no way with an inherited IRA, once you pull the money out, there's no way to put it back in. So on your personal retirement account, if you were to pull the money out and then change your mind and decide you want to put it back in or invest it with another place, you can do that. But once you pull money out of an inherited IRA, there's no putting it back. Other thing that's happened sometimes is they may ask the custodian, meaning the investment firm that the account's with, and they may say, send a death certificate, we'll send you a check. Once the check's cashed, there's no way to put it back in. Or similar to the story I just told you, the corporate plan, like a 401k, may require it be paid out within 1 year, which means that money is all going to be taxed in 1 year as compared to being spread out over 10 years. Now you may be wondering why it's significant, whether you take it out in 1 year or you take it out over 10. If you were to take the entire amount in 1 year, it's going to put you in a higher income tax bracket because you're going to have more income in a 1 year period. If you were to spread it out over the 10 years, it's going to be taxed at a lower rate. The worst thing your beneficiary can do is roll the retirement account into their own plan. We actually had this happen. The financial advisor actually told the client to do it. Fortunately for the financial advisor, the account was only $5,000 because what happened was this client took the inherited IRA, put the $5,000 in their own retirement account. That's an improper contribution to a retirement plan. They owed income tax on the $5,000, plus they had a penalty for that improper contribution. The financial advisor did pay the penalty for that client. So we always warn people it can't be rolled over into their own. Or really the most common thing is the beneficiary, their spouse, or another third party influences them to spend it. Because most inheritances are treated exactly like lottery winnings, which means they're blown within a year. So when we're thinking through leaving stuff to beneficiaries, how many of these apply to your beneficiaries? The wrong people eventually is inheriting the assets. And let me give you how that happens. If you were to leave money to your daughter, and your daughter passes away, she most likely is going to leave it to her husband. And her husband, when he remarries, because 83% of men do, when he remarries, he's going to leave it to his new wife, which means your grandchildren are not going to end up with that money. So if it's important to you that it goes from your daughter to your grandchildren, there's a way we can do that, and I'll show that to you in a minute. Also, are there any poor spending habits of the beneficiaries? Are they going to be tempted to blow it in a short period of time? Or are there people in their lives that will influence them to do that? If they have poor money management skills, and when you look at that, you've got to look at, can they manage what they have, but also can they manage what you're going to give them? So a story I tell on some of my other speeches was a lady who inherited $800,000 from her parents. Prior to inheriting it, she was very frugal, very good with money. So if you asked if she was good with money, the answer would have been yes. But she was not able to manage the larger sum and ended up blowing it within a year. Your beneficiary's spouse could take some in a divorce if it's given to them outright. And if the beneficiary is young, elderly, or disabled, or unable to manage their own affairs, it's not a good idea to give it to them outright. Now, one of the very important things is to be sure if you have a beneficiary who cannot handle their own money or is under the age of 18, you do not want to list them directly as a beneficiary. If they're under the age of 18 or have a disability where they're unable to handle finances, the court will have to supervise how the money is distributed, which will end up eating up a good portion of their inheritance, unless we do certain protections, which I'll talk to you about in a minute. Also, a beneficiary could lose their government benefits. If a beneficiary is on government benefits, they can lose those government benefits by having more than $2,000 in their name. Lawsuits, creditors, or bankruptcy can grab the retirement accounts if they're given outright. And then the estate tax when they pass it down. Now, the estate tax exemption right now is large enough that most people don't have to be concerned about it. But when I first started back in the 90s, the exemption was $600,000. And when they look at estate tax, they look at everything you own. So it's your house, your car, the value of your life insurance, your retirement plans. And so a lot of times people will go over that $600,000 number when they don't even realize they have that much in assets. And if you go over the number, the government takes half of it. And when we look at estate taxes, like I said, right now it's $15 million. Most people don't have to worry about it. For a married couple, it's actually $30 million. But every time Congress is in session, they talk about bringing it down. And I think it's highly likely that in our generation that they're going to bring it down. And it's very likely that they're going to bring it down in the next generation. And I'm going to show you in a minute, there's a way you can leave money to the next generation to where they can leave it to their children without having to pay that estate tax. So how can you maximize both the stretch out and the protection for your family? Naming the living trust won't work. So if you name the living trust will require a 5-year payout. We actually create a standalone retirement plan trust to make sure that it falls within the IRS rules to allow that 10-year payout, or the longer payout if you have a disabled beneficiary or a minor child. If you put it in a regular living trust, even if it has language that talks about retirement plans, you still have a risk that you could accidentally not comply with what you need to have it have a 10-year payout. It's a lot safer to have it be separate. So the retirement plan trust is an actual revocable trust, meaning you maintain control. You can change it any way you want to during your lifetime. You establish it now. It's a beneficiary of your retirement account, and it becomes the owner of the retirement account when you pass away. The other real important thing is the account needs to be divided into accounts for each beneficiary's subtrust. And what I mean by that is the beneficiary shouldn't just be your retirement plan trust. It should be 25% to child A's retirement subtrust, 25% to child B's subtrust, and etc. So that way it divides into separate shares. Because one of the ways that we make sure that it actually goes out over the 10-year period is that it has to have, each beneficiary has to have their own trust. We need to keep it separate from the living trust so that we're clear that it's a 10-year payout. So the question still is, why can't I just put it in my living trust? We want to make extra sure that we don't trip across the 5-year payout, because it's a big difference tax-wise for your beneficiaries. The other reason why a retirement plan trust is good is it actually alerts your beneficiaries to the separate tax treatment. Because when they take the money out, they're going to be required to pay income tax on it. And I can tell you lots of stories of people being totally surprised when in January they get the 1099, finding out they owe tax on the money that they've pulled out of the retirement account. So it alerts them that there's going to be some tax related to it, and also alerts them to the fact that they should take it out slowly. Also, having it separate, it's easier for the custodian, meaning the investment firm, to read, understand, and comply with what you've put together. So how the retirement plan trust works is the retirement plan, and in this illustration there's a faucet, and in the faucet it's showing water dripping into a pitcher. The faucet is the retirement plan itself. The drips are the required minimum distributions. They go into the pitcher, which is the trust, and then those pour out to the beneficiary. But if you have a beneficiary who's irresponsible, a beneficiary who's likely to OD on drugs if you give them too much money, then you're going to want those minimum distributions to not be distributed. So the trustee does have the discretion on whether to distribute it. Tax-wise, the trust will be taxed at a higher rate, but if it's going to ruin the beneficiary's life to get too much at one time, it's worth paying a little bit more in tax to protect against that. So let me walk you through a case study. This is Bob and Betty. I'm initially going to walk through with you what happens if they give it to each other outright and to the kids outright. After that, I'm going to walk through with you what we would recommend you do. So Bob and Betty, if they give it to each other outright, primary beneficiary is going to be the spouse. Spouse is going to have the right to do whatever they want to with it. You have the risk that the spouse could leave it to whoever they remarry. They could also pick a favorite kid. They could be scammed out of the money. In this scenario, they have 3 kids. Their oldest child is Bob Jr. Bob Jr. is a surgeon. They're a little concerned that he might get sued related to his work and lose what he's inheriting. They're also a little concerned that if he got divorced, his wife might take it from him. They're also concerned that if he's successful enough and he has enough money to have an estate tax when he passes away, that this money will be taxed at that point. Middle child is Jane. Jane lacks the financial experience to manage the money. So if they give it to her outright, she might not make the best investment decisions. Also, Jane has a problem marriage, but actually, to be honest with you, Jane doesn't have a problem with her marriage at all. Her parents just really, really don't like her husband. And so their concern is that if they leave it to Jane outright, she's going to, when she passes away, leave it to her husband. And then he may leave it to whoever he marries next. And then the youngest child is Joe. And Joe's the kid that never quite gets it right. So Joe, and actually there could be a variety of things that Joe could be. So Joe could be irresponsible and someone who needs to be taken care of. He also could have a disability that makes it where he can't take care of himself. We've had a few clients that their Joe has been someone who's just really compassionate. And if he has more money than he currently needs, he's likely to give it away. So they're concerned that if they give him too much all at once, he's going to blow it in a short period of time. So will your retirement plan properly protect against unwanted third parties and the federal government? So the smart way, what we recommend is a retirement plan trust. The retirement account, you'll probably still have your spouse as the initial beneficiary. A lot of my clients have it go to the spouse in a trust. And the advantage, there's several advantages to that. One, it makes sure that the spouse leaves it to the kids. It also protects against if your surviving spouse becomes incompetent in the future, so unable to handle their affairs, it would allow somebody to come in and manage the money for them. And if it's in trust for the spouse can use it for anything they need or want. You could have them be in charge. And then in the event they become incompetent, we have people named to be in charge next. So in dividing it among the kids, when we get to Bob Jr. is responsible. So the parents have no doubt, Bob and Mary have no doubt that he can be in charge of his own trust, will handle it well. But leaving it inside what we call a heritage trust will make it where it doesn't get taken away if he gets divorced, sued, or has creditor problems. It also avoids that second estate tax when he passes it down. And then in talking it over with Bob and Mary about what to do about Jane. With Jane, we talked about it. They feel like she can manage money. She just hasn't had money to manage and she needs a period of time to learn. So what Bob and Betty decided is they want Jane to use their financial advisor to learn how to invest, how to manage money for a 5-year period. And after that, she can be in charge of it themselves. They feel confident that she's going to be able to stand up to her husband and not have him encourage her to blow the money. And one of the advantages to putting it in this heritage trust is making sure that when she passes away, it goes down to the grandkids. And then we get to Joe. And when we get to Joe, over and over, when I meet with clients, the parents say, I want to be fair. So I'm letting Bob be in charge of his own money, Jane be in charge of her own money. Joe is going to get his feelings hurt if he doesn't get to be in charge of his own money. But if you think about it, you probably have been protecting Joe his entire life. So the question is, do you want to continue to protect him even after you're gone? Now, I have people occasionally say, at the point where we're gone, Joe inherits, if he blows the money, that's his problem. But a lot of times, it actually ends up being Bob and Jane's problem. Because is Joe going to go to them for money? Are they going to feel responsible to take care of him? And does he have enough ability to think long term on what he needs as far as making sure that he has enough money for that? And so really all of this, it's individualized to each thing. And that's why when we talk to you, we want to get to know your actual family and get to know what's happening with them so we can make sure we design the plan around that. So with Joe, we need to explore that. So the next question is, if Joe can't be in charge of his own trust, who's in charge? So if you put Bob in charge, and Joe is constantly asking Bob for money, what is that going to do to their relationship? Now, in some situations, I've got a client right now, when I ask that, they said, well, Joe's used to getting an allowance. We give him a certain amount per month. And as long as Bob gives him that allowance, he's not going to hassle him. So in that situation, it would make sense to have Bob be in charge. But if Joe's the type of person that's constantly going to be asking Bob for money, that may not be a good dynamic. So at that point, you may want to add a corporate trustee like a bank to allow to have somebody independent so that way you can maintain your kids' relationship. So the Heritage Trust, which is what we title Protecting Against Divorce, Creditors, and Lawsuits, it's standard equipment in every trust we build. I recommend it for everybody. So let me summarize what we've talked about. The benefits of the retirement plan trust is they maximize the income tax deferral, allowing the money to come out as slowly as possible. And this works even for Roths. So occasionally I have somebody say, well, with Roths, if we pull it all out all in 1 year, we're not paying extra tax. That's correct, but you're losing the 10 years it can compound tax-free. So you're actually losing the benefit of having that income have no tax for that 10-year period if you pull the money out too fast. We can also provide protection for the undistributed balance. And we can make sure it goes to the people you want it to go to. So it goes kids to grandkids, or some of my clients, it goes to nieces and nephews and then great nieces and nephews, or the surviving nieces and nephews. So it stays within the family, goes the way you want it to go. We can also protect against the spendthrift. So the spendthrift is not a thrifty person. The spendthrift is a person that spends everything you give them, plus charges a whole bunch of money on the credit cards. You can provide professional money management, kind of like what we talked about with Jane. It would allow the beneficiary to walk alongside a financial planner. So you might have it like what we did with Jane, where she hires the parent's financial planner, uses them for about a 5-year period, and then after that she's on her own. Or you could also name it in a way that you just make criteria for it. So most financial planners, I think it's like 20% of financial planners last beyond 5 years of being a financial planner, meaning 80% of them drop out in that first 5 years. So if you're setting up a criteria, you might want to pick a financial advisor who's been practicing at least 5 years. So they have the experience under their belt, know how to manage the money and put it together. But they've also, of course, got to have the personality where they want to work with your family member. We can add in divorce protection. So just in case a beneficiary gets divorced. Protection for minors. So if somebody's under the age of 18, if you give them the IRA or retirement plan outright as a beneficiary, court has to supervise that. There actually has to be a guardianship, meaning a court proceeding where they appoint somebody to be in charge of that money for that beneficiary. Then that person has to report to the court on an annual basis how the money is spent. And that can end up eating up a good portion of the money that that minor receives. Much better to have it go into a trust for the benefit of that person. You can still have somebody else be in charge, but the court isn't going to need to supervise how it's spent. You can also protect elderly or disabled beneficiaries. Provide government benefits protections, because if you leave more than $2,000 to somebody who's on government benefits, they end up losing those government benefits. But if you were to leave it to them inside of a retirement plan trust, now it needs to be a separate one that's for the sole benefit of that beneficiary, then they can take it out slowly over their lifetime and it doesn't mess with the benefits that they're receiving. We can provide lawsuit, creditor, and bankruptcy protection. We can minimize that estate tax. And when I say estate tax, I'm really not talking about the tax currently because the number's too high for most people. I'm talking about the estate tax in the future when your beneficiaries pass away and pass it to the next generation, because that exemption may be much lower at that time. And perhaps the greatest benefit of a retirement plan trust is the legacy in your name. So every check they receive is going to have your name on it. So they remember you worked hard to earn this money, should spend it wisely because of that. So should you get a retirement plan trust? You have a will or a living trust to protect all of your other assets. The retirement plan trust is a trust designed specifically to hold retirement plans, but it's not one-size-fits-all planning. You need to sit down with an attorney, talk through your family situation. One of the things I try to mention in every speech I give is most families are dysfunctional. Now, for some of you, you're lucky enough that we have to get into cousins before we find the dysfunction. For a lot of us, it's a whole lot closer to home. So when we're customizing, we really need to know about your beneficiaries, know about your relationship to the beneficiaries, and make sure that things are put together in a way that protects you and a way that protects them. So also, when we design the retirement plan trust, it's got to meet a lot of technical requirements. I've simplified it a lot here. When I explain it to clients, I simplify it. But in order to do the retirement plan trust properly, I've been to over 120 hours of training on it to make sure that it complies with the IRS technical requirements. If the attorney drafting it messes up on any of those technical requirements, you're ending up with that 5-year payout. And that's a major consequence if you have a disabled beneficiary. But even for the ones that could take it out over 10 years, you're making the money be taxed faster, and you're making it be taxed at a higher bracket if it's not done properly. We also want to make sure that this new retirement plan trust coordinates with the rest of your estate plan, because your current trust or will may not have the divorce, creditor, and lawsuit protection that the Heritage Trust provides. You may want to add that to your current plan. Also, because the beneficiaries with a disability can take the money out slower, meaning it's going to have longer to grow tax-free, be taxed at a lower rate, it may make sense to leave more of the retirement plans to somebody with a disability and leave other assets to the other people you're leaving money to. So that's another thing that we'll need to coordinate. You may also want to change who's in charge based on conversations that we've had. So where do you go from here? Most people end up procrastinating. Big thing is none of us are planning on dying anytime soon. But really it's important that you put together a plan before you need it. And it's a much easier conversation when we're talking about if you die someday as compared to it being urgent. Now we can help you when it's urgent, but it's much better if we do it ahead of time. We would love to sit down and meet with you, discuss your individual family needs, and put together a plan that fits for your family. Look forward to seeing you.